Hi, you're listening to the Lawyer Society Legal Podcast. In this episode, we'll be talking about the Probation of Offenders Act 1958. As per Section 4, Subsection 1 of the Probation of Offenders Act, the said section or the benefit of probation is only available to a person who is found guilty of having committed an offence not punishable with death or imprisonment for life. Now, there is a very interesting, curious question that arises from the words that has been used in this particular provision. One is, suppose section X is punishable with a minimum of 1 year and a maximum of life or death, and section Y is punishable with a minimum of life sentence and a maximum of death sentence, or with only life or death. The question is whether probation cannot be available only in the case of section X or section Y. Now, to simply put it this way, suppose a court has the discretion to award 1 or 2 years of sentence and the court doesn't want to award the maximum punishment of life or death. Can the accused still claim the benefit of probation? Can the court still award the benefit of probation? Because in the opinion of the court, it doesn't think the particular offense will end up with the maximum punishment given or awardable to that particular offense. To answer this question, we have two different views from the Supreme Court and the High Court of Delhi. One is the case of State versus Lucky from the Delhi High Court, where it was said that when the trial court has the discretion to award a sentence which is lesser than life or death, then it is up to the trial court in the given facts and circumstances of a case to award the benefit of probation to an accused. Whereas a contrary view was expressed by the Supreme Court in the case of Goverdhan versus Chaman Lal, where it was said that even if there is a minimum punishment, if the offense is punishable at all with life or death, it could be minimum, maximum, whatever it is, then the benefit of probation cannot be awarded to the accused. Now, if we were to compare the two judgments, I would say that the Delhi High Court makes more sense. Because, let us consider this one example. Let us look at the offense of sedition, which is section 124A of the Penal Code. It is punishable with imprisonment for life, which is the maximum sentence available, or it is punishable with imprisonment which may extend to 3 years, or it is punishable with only fine. So there are three different punishments, and the minimum punishment is fine. The maximum is an imprisonment for life. As per the Supreme Court's judgment, probation cannot be given to an accused who is found guilty of having committed an offence under section 124A, because the maximum punishment is one of life sentence. Whereas if you look at section 326B of the IPC, which is voluntarily throwing or attempting to throw acid, the minimum punishment is 5 years and maximum punishment is 7 years. Here, if you apply the Supreme Court judgment, it is found that probation is available to the accused person here because life or death sentence is not applicable here. The Supreme Court observation, in my opinion, it doesn't sound right, because in a given case, the accused person may have committed the offense, but considering these circumstances, he would probably be only awarded a sentence of 1 or 2 years as opposed to the maximum punishment of life or death. So if he has only committed the offense to that extent, say 1 or 2 years punishment, then why not give him the benefit of probation? In that sense, I would say that probation should be denied only to offences whose only punishment is life or death and minimum punishment is life or death, so on and so forth. So you can imagine the gravity of offences which will have its minimum punishment as life or death. Let me know your thoughts on this curious interpretation of section 4 of the Probation of Offenders Act. Do comment, share it with your legal community. Follow us on Spotify, subscribe to our channel on YouTube. Thank you for listening.